Hi, Benjamin.
Good morning.
Morning. Hi, Alexandra.
Morning.
Great. Also, yeah, I think a couple of others should join as well.
I've just admitted David. Are we waiting for anyone else, Tanya?
Yeah, I mean, Nico should be attending as well.
Okay.
I'm afraid I don't know his surname, but Nico is the first name.
That's fine. I'll keep an eye out.
Yeah, we can wait a couple of minutes if that's okay.
That's fine. Just to make everybody aware, I'm recording the session for the page on the RSG website. So if you're contributing, please be aware that you're being recorded.
Oh.
As Tanya says, I'll just hang on a minute or two to give other people a chance to join. Okay, Tanya, we have 6 people and me. Do you think we're ready to go?
Yeah, sure.
All right. Morning, everybody. Can everybody see my PowerPoint with the orange screen?
Yes. Yeah.
Yes.
Yes.
Great.
Yes.
What I'll do first of all is just introduce myself and ask you to introduce yourselves really briefly as well. This session is about Brexit and about what's going to happen beyond the end of the transition period at the end of December. My name is Benjamin. I work for an organization called the Public Interest Law Centre. We do quite a lot of work with Roma support group around rights issues relating to EU citizens in general and Roma people more specifically. But I'm not personally a specialist in anything to do with with the Roma community or rights relating to Roma people in the UK, just so that you're aware. So this session is really about EU citizens' rights in general, with a focus on those groups who might be vulnerable for one reason or another, either because they're homeless, or because they're on a low income, or because they don't speak English, or for a range of other reasons. So that's me. I'm Benjamin. Is it okay if other people introduce themselves just briefly, starting with Tanya?
Hi, I'm Tanya, and I'm I work for a project called Ketane, and part of this project is about, I mean, Ketane, you know, as many of you might know, means together. So it's the aim of the project is to create a sense of togetherness amongst different Roma organizations in the UK, and to try and connect them to their local law centers, as well as enabling Roma community members to access legal expertise when it matters, so that it can have a beneficial effect on their lives. I talked at the beginning in terms of this training. I was talking to Alexandra, one of the Roma advocates that we know. And she was actually the one to express the need to have a training on this. Hence, I approached the Public Interest Law Centre, and this is the result basically of all these consultations, and so I hope, yes, I hope that you can find this useful, and thank you for attending.
Is anyone else happy to introduce themselves? If you don't want to introduce yourself, you don't have to. But if anybody, thank you, David.
Hi, I'm David. I'm Roma man from Slovakia. I'm living in Glasgow. I work for Community Renewal. I'm doing a employability service in Gowan Hill. So mostly I'm working with the Roma community.
Thanks, David.
Hello. I also just joined in because I couldn't find the link. Sorry.
Hello, my name is Alexandra. I am a Roma community development worker here in Liverpool. How Tanya say, thank you very much, Tanya, for organizing this event. I think that is very important for the community and for us workers that we work directly with the community, because we will be able to understand and to see how we can support after the Brexit with the changing of the law here in UK.
Thank you. Anyone else want to introduce themselves?
Hello,
yes,
my name is.
You go first.
My name is Sami. I work with Alessandra from the Touch Development Trust. Youth on the Touch work with Roma people, young and old as well.
Thank you, Sami.
Okay, and I'm Joanna. I work for Community Renewal in Glasgow as well. I'm a colleague of David and Sabrina, a welfare advisor and also USS advisor, and mostly for the Romanian Roma community in Gowan Hill. So looking forward to hearing all you have to say about what happens after Brexit.
Thank you, Joanna.
I'm Emilia. I work for Community Renewal. I'm a welfare advisor as well, for Slovak, mostly Slovak Roma people. And I'm looking forward to this information because I'm happy that they are all in one place.
Thank you. Anyone else?
Can anyone hear me? Yeah.
Yes.
Yeah, I can hear you. I can hear you, Sabrina.
Okay.
Go ahead.
Yes, my name is Sabrina. I am a Roma woman from Poland. I work with Joanna, Emilia, and David as well. I mostly do the EUSS and some welfare advice, and I work with the Romanian and Slovakian community.
Thank you. Okay, if there's nobody else, I'll make a start. As you can see, the title here is What Next for EU Nationals After Brexit and COVID-19. I'm running quite a few of these sessions in the autumn of 2020, and I'm mainly running them with organizations that work with homeless people, because that's the focus of my work. I understand that not all of you, in fact, maybe none of you work specifically with homeless people. So I will try to adapt my presentation accordingly. We have about an hour and a half until 12 o'clock. The first thing to say perhaps is that there is a lot of information on this topic. It's a big topic, and I don't intend to cover everything in the next hour and a half, simply because we would really need a day or two to cover absolutely every detail. And I'm aware that people get a bit tired and burnt out after a certain amount of time watching a presentation on Zoom. So this session is not going to be exhaustive and comprehensive. What I will say, though, is that if there are areas which you feel you need more knowledge about, I'm happy to run future sessions which are more specialized. So if it would be helpful to have sessions, for example, on housing and welfare benefits in particular, we could think about running those in the future, because I do have training material on those issues as well. But for today, and in order not to overwhelm people and tire myself out, I'm going to focus on giving an overview of what's about to happen in terms of Brexit and the transition period coming to an end. If you have specific questions, you're welcome to interrupt me as we go along, or I will make space at the end for questions as well. And I do really want to hear from you, and to hear the experiences and the concerns of workers like yourselves and of Roma people. And I'll explain in a minute why I'm so keen to hear your views. I might just start, however, by saying a bit about our organization. We are called the Public Interest Law Centre. We are based in London, and we work throughout London and actually nationwide. And we specialize as an organization in holding the government and other public bodies to account over human rights issues. We've done a lot of work around different human and social rights issues over the past 3 or 4 years while we've been in existence. We've done a lot of work around the rights of homeless people, including homeless people who are not from the UK. We've also done quite a lot of work and brought quite a lot of legal cases around the human rights of groups such as domestic violence survivors and victims of police and other forms of state surveillance. So you may have seen on the news recently there has been an inquiry into police spying against some groups from the sort of 80s and 90s onwards. We've also been involved in bringing legal cases on behalf of those people who were victims of police surveillance. But we do have a special interest in sort of representing and defending the rights of migrant communities in the UK. And as I say, we've done quite a lot of work with the Roma support group in the past, and we are really keen to hear the concerns of Roma community groups and Roma activists so that we can do more work together in the future. when we bring legal cases or campaign around issues, we try to make sure that we are working not just on behalf of the individual clients who have the issue, but we try to make sure that the cases we bring and the campaigning and communications work that we do has a wider relevance. And what we're really interested in doing is changing the law and changing policies to make sure that the rights of vulnerable groups are better upheld. Why are we holding these sessions now? Well, as you will be aware, this is an uncertain time for EU citizens living in the UK because of Brexit and because of the end of the transition period. And I can go on to say more about that. You might also be aware that there is quite a strong history of discrimination against some EU citizens living in the UK. I'm sure you will all be aware of that from a Roma standpoint, as we are too. But we have also done quite a lot of work around discrimination against homeless EU citizens and those who sleep rough. And I'm aware that there are, some Roma people do fall into that category as well. So we're very keen to make sure that all vulnerable groups who are EU citizens in the UK have the information they need to stand up for their rights at this time. And we also want to support frontline workers like yourselves to support other people, both to make sure that they're aware of their rights and to to support you to challenge any abuses to rights that you encounter. We are writing a report which will be published early next year around rights issues affecting vulnerable EU citizens living in the UK. So we're very keen to hear from you about issues of concern for you. And we are also preparing a rights guide, which will be a publication, a small publication, which we hope will be of use to EU citizens around this particular issue of Brexit and what's going to happen and how it might affect them. And we hope to be able to produce a version in languages which will be useful for members of the Roma community in the UK. So really keen to hear from you about your views and not just have me talking all the time. So what I want to start by doing is giving a short overview of the changes which are about to come in. I'll spend about 20 minutes or so hopefully doing this, and I have a number of slides to go through. And this will be the main focus of my presentation today. As I say, you're welcome to stop me as we go through and we can have a conversation. But if you'd prefer, you can also keep your questions to the end and we can have a broader chat then about the questions or the concerns that you or the people you work with are having, or if there is anything you feel like you haven't anything you feel like I haven't covered during this session that would be useful for us to either discuss today or talk about in the future. But I'll begin by saying something about the old system of EU free movement, which is coming to an end at the end of 2020. But before I talk about the changes and what's new, I want to give you a picture, in case you're not already aware, of what the old system was like and in what these changes mean. People from the European Union are free to move across borders and live in any other country in the European Union. In fact, this doesn't just apply to people in the European Union, it applies to people in the European Union and people from Norway, Iceland, Liechtenstein, and Switzerland. These countries are not in the European Union, but their citizens broadly enjoy the same rights to free movement as citizens of countries which are in the European Union. So residents of all of these countries can cross borders within the EU, and they can seek employment, and they can live in other countries in the EU, so long as they do not amount to a burden on the welfare system. That's what the rules say, that you can live in another EU member state so long as you are not a burden, so-called, on the welfare system in that country. If you're an EU citizen, or an EEA citizen, and EEA stands for European Economic Area, and it describes this slightly wider group of countries, so the EU plus the other 4 countries that I mentioned. If you're a citizen of one of these countries, you, at the moment, up until the end of this year, you can come to the United Kingdom freely, and there are no requirements on your stay during the first 90 days that you're here. You can come and you can look for work, or you can come and just live. You can come for a holiday. You can do what you want. This is under the current system. However, under that system, once you've been in the UK for 90 days or 3 months, in order to have a right of residence here, you need to prove that you are doing something called exercising treaty rights. Now, this is a technical term, and it means that you are fulfilling one of the conditions that allows, under European law, EU citizens to have free movement within the EU. There are various ways you can exercise your treaty rights, and I've listed a few of these in my slide here. You can be a job seeker, a worker, you can be a student, or you can be a person who is self-sufficient, which means that you have enough money that you don't have to rely on the state to look after you in the country that you're going to, or the country that you're residing in. The system of treaty rights is a bit complicated in the sense that not all treaty rights give you equal, not all categories of person exercising treaty rights enjoy the same rights. So if you're a worker, you have more rights in the UK than if you're a job seeker. If you're a job seeker, your right to be in the UK is more limited than it is if you're a worker, for example. But you do still have the right to be a job seeker in the UK under the old system, or the system which we are leaving. Under this old system, which is still in operation now until the end of the year, if you exercise your treaty rights for 5 years or more continuously, if you exercise your treaty rights for 5 years continuously, you can acquire an immigration status which is called permanent residence. This is the equivalent of indefinite leave to remain in the UK. And this gives you more security in terms of your right to stay in the UK for as long as you want. Once you have acquired permanent residence or indefinite leave to remain in the UK, you have many of the same rights as a UK citizen, including around things like welfare benefits or homelessness assistance if you need help from the council when you become homeless. And you also have the right, from an immigration point of view, to stay in the UK for as long as you want. There are no restrictions on your stay. But in order to acquire that status under the old system, you need to be exercising your treaty rights for 5 years in a row or more. So, for example, if you have a job for 5 years, without interruption, you can acquire permanent residence on that basis. Now, the UK has decided, in its wisdom, through the Brexit referendum, that it doesn't want to be part of that system anymore, and that it wants to leave the European Union, and it doesn't want to have free movement for EU citizens within the UK, and it doesn't want UK citizens to have free movement in other countries of the EU. This is what the Brexit vote. And our leaving the EU, this is what it means. So at the end of this year, we are going to have a new immigration system, effectively. And that EU free movement system, which I just described, will come to an end. So on this slide here, I've got a few kind of key dates and key milestones in the Brexit process, which it's useful for people to have in their heads when they're thinking about this issue. The UK left the European Union on the 31st of January this year. So, nearly 11 months ago, or 10 months ago, we left the EU. So we are already not a member. And the government was very clear that what it wanted to do once Britain had left the EU was to introduce a single immigration system for everybody. So every foreign national, every non-UK citizen living in the UK or coming to the UK would be part of the same immigration system. Whereas previously we had a two-tier system whereby people from the EU found it easier to come to the UK and live and work here than people from outside the EU. What we are moving towards now in 2021 is a single immigration system for everybody, in which EU citizens no longer have free movement and no longer have preferential treatment in terms of this two-tier system. Now, what we thought was going to happen at the end of this year was that we were going to have what people talk about as a cliff edge at the end of December 2020. We thought there was going to be, on the 31st of December, we thought everybody's rights were suddenly going to change, and then on the 1st of December 2021, we would have an entirely new system. This is what we thought was going to happen. In fact, what the government has decided to do is have another kind of two-stage process by which the rights of EU citizens living in the UK will change after Brexit. The old immigration system is still going to end at the end of December 2020. That's still happening. But the government has decided to introduce a temporary immigration system for EU citizens, which will run from the 1st of January 2021 until the 30th of June 2021. And only after the 30th of June 2021 will we have an entirely new immigration system. Some things will change on the 1st of January, but some things will stay the same. So we have two dates to keep in mind, the end of December and the end of June next year. And it's kind of important to be aware of this. Another thing that it's worth bearing in mind is that if you are an EU citizen who needs to apply for settled status or pre-settled status under the EU settlement scheme, and that is all EU citizens, really. If you're an EU citizen and you want to stay in the UK beyond this year, you need to apply to that scheme if you haven't already. The deadline for that scheme has been extended until the 30th of June 2021. So EU citizens can continue to apply to that scheme until the 30th of June 2021. However, we are encouraging everybody, and we think it's a really important message actually, to make sure that they and the people they are working with apply to the scheme before the end of 2020. Even though the deadline, the hard deadline, is June 2021, we think it's really important that everybody applies before the end of this year, and I can go on to explain why that is. Can I just ask quickly, is everybody comfortable with the EU settlement scheme and knowing what it is and how it works? Is it going to be a kind of waste of everybody's time for me to go over it, or would you like me to talk about it? It would be good to hear people's opinions.
I mean, you can still talk about it. It would be interesting.
Yeah, I think it is interesting.
Okay, that's fine.
Yeah.
If you already know all of this, you can turn your ears off for a minute or two. But I just want to run through the key points of the EU settlement scheme for those who find it useful.
I think it's useful even for us who already know about it. It's good to get a refresher.
That's fine. Okay. The EU settlement scheme is a free scheme which has been introduced by the government in order to give citizens of the EEA, and remember that's the European Union plus those 4 other countries that I mentioned, Norway, Liechtenstein, Iceland and Switzerland. It's been introduced to allow citizens of those countries to secure their immigration status in the UK beyond Brexit. If you're an EU citizen, you can apply to that scheme, and you have to if you want to stay here. The scheme is also open to the non-EEA family members of EEA nationals. So that means, for example, if you are a Ukrainian citizen, for example, and you are married to a Polish citizen, and you both live in the UK, the Ukrainian citizen can also apply to that scheme, even though they are not an EEA national themselves, because they are the family member of someone who is. So this is important to be aware of. I don't know how many of the people that you work with are affected by this, but it's important for people working in some organizations in particular, because there are quite a lot of people in the UK who are not from the European Union, but who are married, for example, to people who are, and they can also apply. The EU settled status scheme is designed to be fairly simple to apply to, and it's an online form. You can do it on the internet, and for many EU citizens, people who've got a computer at home, people who have a national insurance number, people who speak good English, it's been quite an easy process to apply to the settled status scheme. And the government claims that it's very easy for everybody. In fact, as I'm sure you are aware, and we are aware as well, for some EU citizens living in the UK, applying to the EU settlement scheme is much more complicated. If you don't speak English, if you don't have easy access to a computer or a smartphone, if you're not digitally literate, if you are a homeless person or a person with a mental health condition, or a person with a learning disability, or a person who suffers from dementia, or a person who does work in the informal economy and so doesn't have a national insurance number, it might not be as simple for you to apply to the EU settlement scheme and get a positive decision. So it's very important, obviously that those groups of people are made aware of their rights under the scheme and that they are supported to apply. And so one of the things that we've been doing over the past year or so is assisting these more vulnerable groups with applications to the EUSS scheme. And I'm sure that some of you have been doing that work as well through the Roma support group or other organizations. As I said, this settlement scheme is open until the 30th of June next year. So there are still a good 6 months or so before the deadline, 7 months even. However, people really need to apply before the end of the year, and I can tell you why, in more detail in a moment. Unlike the old system, you remember a few minutes ago I told you that in order to acquire permanent residence in the UK under the old system, you had to be able to prove that you had been exercising your treaty rights in the UK, for example, by working for 5 years or more. Unlike that system, the system of applying for settled status under the new scheme is somewhat simpler. You don't need to prove that you have been exercising treaty rights, working, for example, in order to apply to this scheme. You only need to show that you have been living in the UK. And there are various ways that you can show that. For some people, it will be through a national insurance number that shows your work records. For other people, you will have to be more creative about the evidence that you present to show that you've been living in the UK. It might be utility or council tax bills or medical records, or there are other ways in which you can show that you've been living here. All you have to do is show that you have been here. It's an online application for most people, although in some circumstances, including for people who don't have a valid passport or a valid national ID card for the country that they are a citizen of, for those people, they may need to make an application on paper. But for most people, it will be an application online. And you do need a valid ID or passport to make the application, and that has proved an issue for some of the people that we know and that we work with. Another issue that we wanted to bring to your attention in these sessions is that if you have an outstanding criminal conviction or you have a pending criminal case, we are advising people to seek advice from an accredited immigration advisor before making an application to the EU settlement scheme. Having a criminal conviction does not mean that you can't apply. You can apply, but you have to declare your conviction. And the government, unfortunately, has not been very clear about which kinds of criminal conviction might cause an issue for people when they are applying. Most people with fairly minor criminal convictions will be fine. But if you have a slightly more, serious, in quotes, criminal conviction, which gave you, a longer prison sentence, for example, or if you have an outstanding criminal case that hasn't yet been resolved, it may be more complicated for you to acquire your settled status. So we're advising people under those circumstances to make sure they get help from an immigration advisor so that they don't end up either getting a refusal or, as we have seen in some cases, a long delay in being granted settled status or pre-settled status. In some cases, we've seen that the Home Office simply sits on people's applications for many months if they have an outstanding criminal case. There are two kinds of status which you can acquire through the EU settlement scheme. You can acquire pre-settled status if you have lived in the UK for less than 5 years, and you can apply for settled status if you have lived in the UK for 5 years or more. Settled status is the equivalent of permanent residence in the UK under the old system. It's also the equivalent of what we call indefinite leave to remain. If you have settled status, you are entitled to things like welfare benefits and housing assistance in the same way as a UK citizen. So settled status is the best one to have of the two. However, you can only get this if you've been here for 5 years or more. If you have pre-settled status, if that's the result of your application, this allows you to stay in the UK, but it also means that you have to continue to prove your entitlement to welfare benefits or other kinds of social assistance in the usual way. You don't have automatic access to eligibility for benefits if you have pre-settled status. I also wanted to point out that everybody needs to apply for settled or pre-settled status, even if you already have permanent residence under the old system. And this is why it's important. If you want to live in the United Kingdom beyond the 1st of January next year, you need to apply for settled status. Otherwise, you do run the risk of being undocumented effectively in the United Kingdom. And that means, being undocumented means, first of all, that you could be at risk under certain circumstances of being removed from the UK by force. But it also means that you might have issues around accessing healthcare, housing and benefits, or proving that you have a right to work in the UK. Now, the precise details of this are a bit complicated, and we can go into them. But this is why we're pushing very hard, the idea that people really need to apply by the end of this year, even though they can technically apply until June next year. If you don't apply by the end of December this year, you will still be able to apply next year, but you may lose certain rights and entitlements and be at risk in the meantime. And I'll come back to this in more detail. One of the reasons why this is important is that the Home Office has a history of trying to remove from the UK EU citizens who it doesn't want to be here. And particularly this has affected vulnerable groups of people in the past, including homeless people, and also including, quite a few people who are Roma migrants from the EU have been caught up in those policies. Between 2010 and 2017, there were various policies through which the UK government tried to remove EU citizens from the UK if they were homeless or rough sleeping. And so quite a few Roma people were affected by those policies. And it's important to point out that once the old system of immigration, which made things easier for EU citizens, goes away, as it is soon to do, it will be easier than it used to be for the UK government to remove or deport EU citizens. If, for example, they commit a criminal offence, it will be easier for them to be removed by the government than it used to be, now that free movement rules are going away. I also wanted to point out, because this is an issue that we do quite a lot of work on and will continue to do so, the government is once again trying to remove or deport foreign nationals who sleep rough in the UK. They've introduced changes to the immigration rules, which mean that if you are a rough sleeper, if you sleep outside and are discovered to do so, this could be used by the Home Office in some circumstances as a reason to refuse you a visa or to cancel your existing visa or your existing permission to be in the UK. So this is obviously very concerning. And we are very keen to hear from any organizations or any individuals who are concerned about this, because we are bringing a legal challenge to the government to try and stop it happening. So if this is something that you or anybody you work with is affected by, please do let me know, either in the meeting or we can have a conversation by email or on the phone afterwards. Another point that I wanted to make, which I think is very important, is that there is no ID card once you are given settled status. There will not be, you know, a card with your photo on it that you can use to prove the fact that you are entitled to stay in the UK as an EU citizen or entitled to access services. This is going to cause problems for some people. In order to prove your settled status or your pre-settled status, once you've acquired it, you will need to log into an online system and access what's called your digital profile. And we are quite concerned that some vulnerable people, including some of the groups that I already mentioned, you know, people who have disabilities or older people or homeless people, or people with a low level of digital literacy, may find it difficult to prove their status even if they have it, because there is no ID card. So we are encouraging everybody, and we're encouraging organizations who work with those people to be really, really clear about the importance of them, the importance of them keeping a record of their immigration status and understanding how to access it. And if necessary, you know, support organizations need to do it on people's behalf, keep those records to make sure that they can prove their status when they need to. Because in the future, people may need to prove their settled status or their pre-settled status in order to access things like housing, welfare benefits, the NHS, things like that, or to prove their right to work under the future immigration system. The other thing that we want to try and make people aware of is that if you acquire pre-settled status, so that's the kind of, you know, the less good or the less secure kind of status for EU citizens, you need to make sure that you upgrade that status to settled status within 5 years. You can't just get your pre-settled status and then sit back and relax. You need to make sure that you upgrade it within 5 years to settled status. Some people, we fear, don't really understand that they have to do that. Now, you have to upgrade your status from pre-settled status to settled status within 5 years of receiving it. But actually, it's much better if you don't wait that long. And it's much better if you upgrade your status as soon as you have lived in the UK for 5 years in total. So say, for example, you arrived in the UK in 2016. If you make an application for settled status or pre-settled status in 2020, you will be granted pre-settled status because you will have been in the UK for 4 years. Within 5 years, you need to upgrade it to settled status. But actually, if you arrived in 2016, you can upgrade your status to settled status in 2021, because by that time you will have 5 continuous years of residence in the UK. And it's to your advantage to do so because, well, for the reasons which I've already outlined, it makes your immigration status more secure. And it also gives you improved access to things like welfare assistance. I won't dwell on this slide in particular, because it's more relevant to organizations working with rough sleepers and homeless people, but only to say that, you know, we've got a pandemic at the moment that doesn't really change very much legally. You know, the system is still going to change in the way that has been anticipated. One of the changes that we've seen through COVID-19 and the pandemic is that many homeless people have been accommodated who wouldn't otherwise have been accommodated. And some of those people are getting help with sorting out their immigration status. Some of them, unfortunately, have also been offered voluntary reconnection to their country of origin. And we're trying to keep an eye on that to make sure that when homeless people from the EU, whether they are Roma people or anyone else, when they're being offered, you know, when they're being told, why don't you go home to your country of origin, we want to make sure that they're being told of all of their options before being told that, and that they're being offered help to stay in the UK and prove their rights in the UK if that's what they want to do. If you want to talk more about that, I'm happy to do so.
Can I ask a question?
Go ahead, David.
What's happened with the people, like they already apply for pre-settled?
Yeah.
Maybe they will go back to Slovakia. They will sit there for 5 years, and after 5 years they would like to apply, and they don't have the evidence. They can apply for pre-settled again.
Tell me again. Give me an example.
Like the person who's already have pre-settled,
Yeah.
They will go to Slovakia for 5 years. That means they don't have proof for 5 years evidence they living in UK, and they will come back after 5 years. If they can apply for pre-settled again, because they don't have the evidence to do just settled, you know.
I understand. Yeah. It's a good point. If you leave the UK for an extended period, then you won't be able to put 5 years together. You need to be in the UK for 6 months out of each year in order to count that year towards your immigration status. So if you get pre-settled status and then you leave for a long period, you're right. You'll need to be careful about doing that. And I think, to be honest, what I'd advise, David, is that those people really need to get advice from an immigration advisor about their specific circumstances, because there are lots of different possibilities in terms of how that might affect their pre-settled status. You know, if they leave for short periods every year, they'll probably be fine. But if they disappear, as you say, for 5 years after they've got pre-settled status, we are not sure yet, because the government hasn't really said what those people are going to have to do. There is still uncertainty around that.
So they can apply after pre-settled to have this pre-settled, like twice.
As far as I know, there has been no announcement about what people are going to do in such cases from the government. And it's an important area. I'll make a note of it, and I will have a chat to our immigration specialist and get back to you if I have any more information. But as far as I know, this is still a question mark for everybody.
Can I say something, please? Can I say something?
Go ahead.
I want to note that if we have pre-settlement status, what I know, what I said, if you go out from 2 years more from UK, you lose your status and the right to apply again. With the settlement status, if you go out for 5 years, you lose your settlement status, unfortunately.
Say that again, Alexandra.
If you go out from UK for a time long of 2 years with the pre-settlement status, you lose the right to apply again and also to live in UK, to come back if you stay 2 years. and with the pre-settlement status. And if you have settlement status, you are not allowed to go out 5 years from UK, because you lose again your right to stay in UK after this period.
So what's going to be more unclear is what happens if you come and go. I think that's the slightly more unclear point. But thank you for that, Alexandra. That's helpful. That wasn't my understanding. But what I can do is I can check on that, and I can get back to you with more clarity about that point.
Yeah, can I add something here?
Go ahead, Joanna.
Yes, I agree with Alexandra. I was actually about to say the same thing that she had just said, that with regards of the family that David was talking about, if they have pre-settled status right now and they go abroad, indeed, they will lose that pre-settled status if they've been abroad for more than 2 years. That's what the rules are like. So my understanding of this case is that if they do go abroad for more than 2 years, they would lose pre-settled status. And I'm not sure they can reapply when they come back, David, because everybody who applies under the USS scheme must do so by the end of June 2021, yes? So I'm not sure if this scheme will still run 5 years from now on when, you know, this family intends to come back. I don't think they'll be able to. I think they will be subject to the new immigration rules, which is non-EU citizens trying to enter UK. Am I right?
I think certainly if they were to leave for more than 2 years, that would be the case.
Yes. Mm-hmm.
But I think there is still a question mark around what happens to people who acquire pre-settled status and don't necessarily meet the conditions to apply for settled status at the end of their 5 years of pre-settled status, because that is still possible. Without leaving the UK for a very long period, you could leave the UK for a significant enough period that you're not able to put together 5 years at the end of your period of 5 years in order to apply for settled status. And I think that's the point that I'd like to get more clarity on, both for myself and for you.
Yes, that sounds like a good idea. But David, I would tell your clients that, you know, if they do intend to go abroad for more than 2 years, then, you know, it's a big question mark whether they can come back, really.
Right.
I think the main point here is, because it's complicated, people need to get advice. People should not, you know, there's a lot of problems sometimes with people kind of assuming that the rules work one way or another way. My advice would always be to make sure people get advice about their particular circumstances, rather than just assuming that they'll be okay. But if there's any more clarity on the specific point that I can get, I will come back to you with that. But thank you, Alexandra and Joanna, for saying what you've said as well. That's helpful.
Thanks.
I mean, this is just one of several areas where we are not quite clear. Anybody who has pre-settled status or settled status by the end of December this year will, at least in the short term, you know, we've talked about this uncertainty around people with pre-settled status who leave the UK, but anyone who has either pre-settled or settled status by the end of December this year will see their rights continue beyond the end of this year. And those people will, broadly speaking, be okay. There is another category of person, you know, so the first category of person is someone who has pre-settled status. The second category is someone who has settled status. A third category of person is someone who doesn't apply in time, you know, doesn't apply before the 31st of December, rather. but who was exercising their treaty rights at the end of the year. So for example, somebody who was working in the UK at the end of December 2020, but didn't apply for pre-settled or settled status by that time. This category of person has until the 30th of June 2021 to make an application. And in the meantime, under the temporary regulations, the temporary immigration rules that I mentioned at the beginning, their rights will continue in the usual way. So if they were working at the end of 2020, they will continue to be able to work in the UK legally, to access benefits if they are entitled, to use the NHS and that sort of thing. But they do need to make an application before the end of June. There is a fourth category of person which we are quite worried about, however, and that is those people who fail to make an application before the end of the year, and who were not or were unable to show that they were working or otherwise exercising their treaty rights on the 31st of December. Those people, because the old immigration system is going away, those people will not be able to start exercising their treaty rights after the end of the 31st of December. Those people can still apply for the settlement scheme if they were living in the UK on the 31st of December, but in the meantime, they could face difficulties in terms of proving their right to work or to access benefits or other services. So we're quite concerned about this group of people. If they're not working and they don't apply, they could be in a bit of trouble. Technically, they could also face immigration enforcement action as well, although the government claims that that group of people will not be targeted for immigration enforcement. They will simply be encouraged to apply before the 30th of June. But this is again to underline why it's so important that people make their application by the end of December rather, because even if they intend to make their application next year, they need to be aware that they might lose some rights in the meantime. As David has pointed out, there are also other categories of people, including people who have status and then leave the country and then want to come back. And those people could face sort of complications, both in terms of returning to the UK if they're unable to prove their settled status, or if the border officials for some reason don't have a record of their status online. You know, this sort of thing can always happen. And there is no ID card, or new arrivals from the EU who've never lived here before and who decide to come here after January. Those people will still be able to come to the UK between January and June without a visa. That's our understanding. However, they won't be able to access, they won't be able to start exercising their treaty rights, and they won't be able to apply for settled status. So there are various different categories to be aware of. And we know it's very important that people get advice where they possibly can from an accredited immigration advisor about their individual circumstances. I wanted to make just one more quick point before we talk some more. I've talked for a bit longer than I wanted to, but I think I wanted to mention this point about the right to work. The government is being a bit misleading or a bit contradictory on this topic. They're saying to employers that they're not allowed to ask people for proof of their settled status or their pre-settled status until after the 30th of June next year. That EU citizens can continue to work just by showing either their national ID or passport. However, if you do not acquire pre-settled status or settled status by the end of the year, and you weren't exercising treaty rights at the end of the year, this year, the immigration rules now suggest that you will lose your right to work. So there is somewhat of a contradiction here, and there is a risk that some people may end up in a situation where they are working, effectively working illegally without knowing it. And we're quite keen to keep an eye on that. If you have anybody who's worried about their right to work, it would be interesting to hear from you on that point, either in this conversation or afterwards. What is clear is that after the 30th of June next year, if you want to work in the UK as an EU citizen, you will need to provide either proof of your settled status or your pre-settled status, or you will need to have a visa like anyone else from another part of the world. That's all I wanted to say about that, really. And I want to kind of throw it open to you to ask any questions or raise any concerns, or to talk about any kind of fears that you or the people you work with have around this issue. And I'm happy to try and answer any questions I can, or if I can't answer the question, I will try and get an answer from it, from one of my specialist colleagues. There are some questions that we still just don't know the answer to. And in those cases, we'll try and keep you updated as we go along.
Hello, I would like to ask a question, if
Go
possible.
on.
Right, so we had several questions from our beneficiaries in Newcastle, and they were asking how can they prove their right to settled status, because as you know, they have to go online and access the website where they can show the code. But very frequently, when when they are at the border trying to get into UK, they will be asked for that permit. And if they don't have access to internet, or if they don't know how to access the website, because most of them they're not very technical. Either it could be like the technology skills that they're missing, or maybe the language skills. And we were asked many times, how can we prove if we print something on a paper, would that be a valid evidence at the border? Or and what would you suggest? Because it's like I said, it's very difficult for some people to access that, and sometimes the website doesn't work. And I'm sure many people will struggle to prove their settled status at the border. Do you have any information on that? And if you can enlighten us a little bit, please.
Well, just quickly, Niku, is this happening to people already?
Not at the minute, because they can still travel with the passports. But from 1st of January, I'm pretty sure they will be requested to show their right to reside in the UK. But from my experience, when people had to prove their settled status, when accessing benefits or something similar, no, they relied on somebody else to to follow all the steps to get the code.
Yeah.
So they can't do it independently, and it's that's really difficult, because it's when you have like a printed document or something that is valid, you can just show it. But with this system, you just have to access the technology, and many people they can't. For the simple reason that they don't know how to use the internet, or to follow those steps. You need to get a code through a text, and then you have to put a code into. It's quite difficult, and I'm sure that there will be many people who are struggling, because at the minute they'll have to see us, and we have to access their account and give them the code. But if you're by yourself at the border and you can't do this, that would be quite difficult.
Now, I understand what you're saying, and I think In terms of access to services, you know, benefits and things like that, I think you're right. In theory, at the border, this shouldn't be an issue, because at the border, if you have a valid national ID or passport, what should be happening is that the border official should be looking at your national ID and passport, entering the details into your system, and it should pop up for them what your immigration status is. And that should not be something that you need to do yourself at the border.
Yeah,
Now,
I don't have any cases where, you know, any situations where, you know, that was a problem. But just for example, if somebody, you know, changes their passports, and, you know, like many Roma, when they go back to their countries, if the passport expire, they'll change the passport, and they won't be able to update their passport number on the system unless somebody does that for them. So if they go to the border and the border agent will input the passport number, that will show that they don't have the right to reside, because they have changed their passports, and that can be an issue. So, you know, it's one of those situations when, you know, because when people go back to their countries for a short period of time, they usually update all their national documents like national ID card or the passport, and they will have a new number, and that won't match in the home office system. So I know that could be one of the situations that they could be faced with. And, you know, my question is, if you have any information, if the home office intends to issue some kind of documents or cards that can be, you know, that can act as a proof of settled status. Do you have any information on that?
I mean, there's certainly no intention for them to issue cards. They've refused to do so. What I will do is I will ask our immigration specialist whether or not he has any more information than I do about this particular issue, because I see what you're saying about people who change passports. You know, it should be that the system is sophisticated enough to recognize that they are still the same people. But I think you're right that we will have problems, and that people will have problems at the border, and that we really need to keep an eye on this. And if the people you're working with do start to encounter difficulties, please let us know and we can raise that. However, in the meantime, I will try and see if I can get any more information in detail in terms of an answer to that question, Nico, and I'll come back to you about that. But it may be that it's just it's another question mark for the moment, and that's something we need to keep an eye on. The government, unfortunately, has not been very good at answering these kinds of questions. But I will come back to you.
Thank you for that.
You're welcome.
Yeah, I could add that we have had similar issues with our existing clients already. So I agree with everything I've heard about this, because our clients, for some reason, they change phone numbers pretty often.
Yeah.
It happens that they change phones as well, or they lose their phones, or the phones get stolen. We had lots of situations where a client could not log into their immigration status because they no longer had their phone number or the email address or access to the email address they had used upon application. And that can prove really tricky, because in this situation, the only option is to contact the resolution center and explain and have them update the client's details. But the client was never able to do that themselves. We always had to assist with this. Again, changing their ID card or passport, again, even though we did tell our clients every time we had submitted applications that they would have to report all these change of circumstances. But, you know, the majority of our clients who had issues came back to us with that. It was like, you know, they forgot, or they weren't really listening, and the problems did occur, you know. So it is difficult. And, you know, in terms of entering UK, I mean, you know, free movement should still be on really this year, but I know from our clients that family members who tried to come to the UK recently, some of them were actually not allowed access and they were turned back. So, you know, the problems are already happening.
Is that EU citizens, Joanna,
Yes,
who've been
yes.
turned back?
Romanian, yes, Romanian Roma clients of ours, yes, family members of our clients. I was the most recent one I've heard of about a few weeks ago. Someone's mother was coming to the UK and they were turned back. It was actually a whole minibus that was not allowed access at the entrance to the UK. I think it was Dover. Yeah.
And was any reason given for that?
No, they don't know of why that happened. You're just not allowed to enter.
Yeah, I mean that is shocking, and well, it's not. It's bad, but it's not shocking. Maybe.
No, nothing shocks me really. I mean, this is nothing but prior to the lockdown, really in March, prior to March 2020, there were many cases at Glasgow Airport where EU citizens, well, Romanian citizens coming to the UK were not allowed to enter at the airport. And I know that from, again, family members or a friend who's an immigration lawyer and who was assisting with such cases. And I don't mean to sound, you know, ridiculous, but just one example, one young girl in particular that needed legal assistance with that, they would not allow her entry purely because she was wearing high stiletto heels, and they said that she looks like she may be a vulnerable person who could be used for prostitution here, based on the fact, based on what she was wearing, you know, and that was the most ridiculous reason I've ever heard.
Of course,
but it just shows you know.
Yeah, I mean, this is one of the reasons why these sessions are so useful for us, because we're able, you know, there is often a big difference between what the law says and what actually happens in practice. And it is, please, you know, maybe we can, this is something we can be in touch with about, in the future, Joanna, because it's really interesting to hear these experiences as we kind of plan our work for the next year or so. So perhaps we can be in touch again about this, because as you say, and as Niku said, you know, there are going to be more issues of this kind. And what's really important is that we kind of work together to monitor those issues and to find the best way to resolve them where we can.
Yes, I agree. And I would be happy to put you in touch with my friend, the immigration lawyer. I mean, he's a Romanian lawyer, but practicing law in the UK. And I know, subject to GDPR rules and so on, I'm not sure how much he could discuss, but as a general conversation that you could have with him, he could give you examples of situations in which, you know, in his opinion, EU citizens were denied entry into the UK. I think it would be a good insight into what's actually going on at the borders.
I think that would be excellent. Let's be in touch about that. If you don't mind passing your email address through Tanya, we can be in touch.
And one of my questions relates to indefinite leave to remain. If I'm allowed to move on, I do have. Yeah, I have. We have quite several Polish Roma clients who have lived in this country for many years, and they have exercised their treaty rights. But for whatever reason, many of them don't have valid IDs. Like, you know, you're lucky if the children have birth certificates. And I'm finding a few situations where the let's say an indefinite leave to remain document was issued to one of the parents, but the children's names are not on the indefinite leave to remain document. So what's going to happen to people in that kind of situation? Because they, you know, they can't, they basically, it's almost as if they can't prove their, you know, their existence in the system. And many of these people work in precarious employment, so they don't have contracts, they don't have pay slips. And so what's going to happen to them? Because yeah,
So let me just check that, Tanya. This is people who have been granted indefinite leave to remain,
Yeah, I'm talking about more dependents of people who have indefinite leave to remain. Yeah.
And those people who have indefinite leave to remain, why do they have indefinite leave to remain rather than another immigration status? Is it because they had refugee status?
Well, some of them did, some of them didn't. I'm not quite sure what. I mean, many EU nationals, to be honest, who've lived in this country for many years, have indefinite leave to remain.
Okay, I mean the usual thing is if you're an EU citizen who's lived here for a long time, you'll have permanent residence.
Permanent residence, yeah, but many of our clients seem to have indefinite leave to remain. That seems to be the case.
Yeah, I've met people like that too. In my experience, those are usually people who came and were refugees in the 90s or at another time from.
Yeah, not all of them, but yeah.
Okay, all right.
Yeah.
So those people, they've got indefinite leave to remain, but their dependents are not listed.
No.
And their dependents don't have other forms of ID or birth certificates.
Apart from birth certificates. Yeah.
How many people are we talking about? Do you think this is quite rare or quite common, Tanya?
No, it's quite common. It's quite common. I mean, we have asked PILC to produce a short video, which we have posted on our social media platforms on indefinite leave to remain. A lot of our Polish clients face this situation.
Okay.
Yeah.
All right. I mean, as I'm not an immigration specialist. Does that immigration video, that advice video, does that tell you what to do?
Well, it assumes that the dependents have IDs. Yeah.
Okay, so this is something that I need to go back to my colleagues about, and I can be in touch. I can be in touch.
Yeah. Okay.
But I think yeah, it's really important to raise, and I will try and get you a more conclusive answer if I can.
Thank you.
You're welcome. Anybody else? We have about 5 minutes. Does anybody else have anything else they want to raise or ask, or sort of, you know, things that the people they work with are concerned about when it comes to Brexit? Are the people you work with all getting themselves sorted out, or are there lots of people who you worry about who haven't sorted their immigration status?
I would have another question, if possible.
Niku, go ahead.
Right. So I was wondering, in a situation when the border agents would refuse entry for somebody who has all the legal rights to enter the UK territory, what would be their options in terms of complaining or doing something on the spot? Is there a number they could ring, or somebody they can complain to if they're being denied to the right to enter the country for no sufficient reason? If it's an abuse, where can they report that?
It's what they need to do is seek immigration advice from an immigration lawyer working with the UK immigration system. But that's not necessarily going to be an easy thing for a person to do in the moment. The other problem is that, as you might know, getting legal aid or getting help for free immigration advice if you're on a low income is not very straightforward. And in that case, you would not be able to get legal aid. You would not be able to get the government to pay your legal costs. So unless you have access to money, which will help you, pay for a private solicitor to advise you, it may be difficult to resolve that in the moment. We are happy to be contacted about those cases. but we are obviously not, we're not an emergency service, so we can't, you know, we can't guarantee that if someone turns up at the border, we're going to be able to help them in the short term. If people experience that, however, we are very keen to hear about it, and we want, you know, we would want to emphasize, I suppose, as always, the importance of not just allowing yourself to be told by a border guard no, but to ask for, you know, an explanation and reasons in writing, which could then be used by a solicitor or an immigration advisor later to advise you around whether or not what's been done is lawful on the part of the border authorities, and whether or not it could be challenged. So I don't think there is an easy way that people can challenge that in the short term, unless they have a private solicitor they can contact. But in the more long term, my advice is to, you know, try and get reasons in writing if possible, or verbally, and then you record them and you write them down, and then contact us, and we can try to advise and assist where we can afterwards. But I think, you know, don't want to sugarcoat it. There are going to be quite a lot of issues like this, and they're not always going to be easy to resolve immediately.
All right, thank you for your answer.
You're welcome. Anybody else have anything else they want to raise or discuss? And if not, my final question would be: would it be useful either early in the new year or slightly later to run more sessions like this, or to run different sessions on special themes, you know, perhaps relating to housing or benefits? Are there any areas which you think that we need to be producing information or material about and running sessions about, beyond the issues that we've already talked about, and which I will raise with my colleagues?
Could I ask another question, please, if that's okay?
Go on, Sabrina. Yeah.
So, see, because all of the clients are asking us for the past year, see, after December, even if they have maybe like pre-settled residents and they're not working, are they still able to stay in the UK?
Say
Or
that
is it,
again.
if there's clients that have pre-settled
Yeah.
status and are not working at the moment, are they still able to stay in the UK?
Yes.
Yes.
Unequivocally, yes. If you have pre-settled status, you can stay in the UK until at least 5 years after that pre-settled status was acquired. So you don't have to be working.
Okay, that's fine.
You may, you know, if you want to access benefits or certain kinds of social assistance, you may need to prove that you're working.
Yeah.
But you have the right to be in the UK if you have pre-settled status. No arguments.
Okay, that's fine.
Okay.
And Benjamin, I do have actually, and I don't know what the others think, and maybe they can voice their what they need. But something that we would benefit from, and I think many people would, is access to welfare benefits, you know, of pre-settled versus settled status. There is a vast, but we're having huge problems with accessing benefits with for some of our pre-settled status clients. So it would be useful to have more of an insight into that.
What kind of problems, Tanya?
Just I mean, just, you know, accessibility to, you know, how accessible services are in when you have pre-settled status. Like, what realistically, what are your entitlements? I think we need clarity around that.
Okay, I think that's a good topic for another session then, perhaps.
Yeah, definitely for another session.
I will have a chat with my colleagues. I'll see if we can do something like that early in the new year.
Okay, thanks.
Okay. All right, so it's 12 o'clock, so I want to end. Thank you all for contributing and for having me, and also for in some cases having better knowledge than me about the settled status scheme. It's really useful to have this conversation, and I hope that it can be an ongoing conversation. Tanya, if you can pass my email address on to everybody, I'm very happy to be in touch individually by email or by phone if people have more questions or if there's anything else that we can help with, because we don't have all the answers, because nobody does. But we are really keen to support Roma people in particular with this issue beyond the end of the year. So let's stay in touch.
Thanks. It's been a really useful training. Thank you.
Thank you, everybody.
Thank you. Thanks for the information.
Thank
Thank you. All right.
Thank you for your time.
All the best.
Bye.
Bye bye.
Thank you. Bye, everyone.
Bye.